Time now for Night Court. The rock group Metallica taking insurers to court over losses from concerts that were canceled due to the coronavirus pandemic. Metallica claims the insurers are now refusing to compensate the band after it was forced to postpone 6 shows in South America last year. But could the unprecedented nature of the pandemic hurt the band's case? Let's start an argument tonight with the co-chair of the Hometown Values PAC, attorney Ethan Behrman, and criminal defense attorney David Bruno. Gentlemen, great to have both of you with us.
Hello, Shannon.
Hi, Shannon.
And listen, I have to tell everyone, Ethan is sort of a Metallica super fan, and he got assigned to argue against the group. But in his heart, I know he's with them. But listen, that's why these guys are pros. So let's start with Exhibit A. This is the complaint over the cancellation policy. As is common in the music industry, before the tour, Metallica purchased a cancellation, abandonment, and non-appearance insurance policy to protect it in the event that any portion of the tour was canceled or postponed. But underwriters denied any coverage obligation whatsoever based on an unreasonably restrictive interpretation of the policy, Ethan.
Yeah, it's not overly restrictive. I mean, the policy is very clear, and sadly, this is the case. Insurance contracts are contracts of adhesion is the term of art that we know about, and so there's not negotiation that happens over these 100 pages often in these insurance contracts, and they have 2 very specific carve-outs for communicable diseases, requiring either one of the band members to be taken out essentially by the disease, or that the venue in which it was canceled was an origin location of the disease. It's very clear. It's too bad for Metallica, but the insurance policy is clear that they won't pay out, and the courts are hearing a lot of these cases, and they're just not even making it past the motion to dismiss, or in California it's called a demurrer.
Yeah, I mean, a lot of these we're seeing from restaurants and businesses in different places who say their insurers will not pay after they're being wiped out by the pandemic. And they're arguing, many of the insurers, that this is just a once-in-a-lifetime kind of event. It goes beyond the policy and what they can do. Lloyd's of London has been named a lot in this particular case, but here's what they say, Exhibit B. They're not an insurance company. It oversees and regulates a market of independent insurers. For that reason, we have no information on any specific policy or lawsuit, and in any event, we are not authorized to comment on matters in litigation. David?
Yeah, this comes down to contract law, and like Ethan said, it does really depend on the policy. And you know, they do have a leg to stand on, I think, because one of the things that they're arguing is that they never really investigated whether or not that venue was closed and why it was closed. And it's a possibility to get out of that exclusion. So it's point 1 of their complaint, which is no investigation. But interesting enough, there was a series of exclusions that were created after SARS many years ago. And it's an exclusion particularly for virus. And it's something that the insurance companies adopted. And this is different. So I think it's another argument that Metallica could use, that this was not the purpose of that particular exclusion, or else they would have addressed it under the virus provision that's previously used by most of the insurance companies.
Yeah, and these insurers have to get wildly imaginative about all the worst case possible scenarios that could happen. Exhibit C, this is from Stanford Law Review, talks about this. Contracts in COVID-19 says, if courts regularly excused parties from their contracts when performance turned out to be tougher than expected, then parties would lose faith that contracts really are legally enforceable. Anything and everything is foreseeable, at least to those with good imaginations. Ethan.
Yeah, I mean, look, the insurance company really does consider all of these, and that's why they have teams of lawyers that build on decades of experience to figure these out. And as my esteemed colleague just pointed out, they learned after SARS. But again, this is just very clear that the exclusion exists. It's within the 4 corners of the contract. You know, you would assume that Metallica has attorneys who read it, but even attorneys who read these on a daily basis can miss these specific exclusions. And it's too bad for Metallica, but I really think that the motion to demur is going to succeed here.
Okay, quick final word from you, David.
Yeah, it's not that the attorneys missed it, right? Because there was pre-litigation communications where there was a claim, and that's why they brought this suit for declaration. They're asking the courts to declare what the policy requires. And it's fairly common, and we'll see as to how this shakes out. It will probably be done on motion, or negotiation and a resolution
Yeah,
in settlement that goes
maybe that.
confidential.
Well, I'm just going to check in with Ethan because he's a Metallica guy. He will know, and he will let us know. Ethan and David, thank you both.